I'm presenting the first part of this presentation about 5 ways to get the best out of your commercial contracts. Just a bit of background about me. I'm a commercial lawyer at Matthews Folbigg, so I deal with transactions like sale of business, commercial contracts, contracts for supply of goods, joint ventures, so or a whole range of commercial contracts. And this presentation is really about me talking about some of the practical issues that I've discovered with clients who have made mistakes and sort of easy things that you can fix to make your transactions work. Just a bit of an overview of what I'm going to talk about. First, I'm going to talk about pre-contract issues. So these are things like heads of agreements and term sheets, things like that parties often enter into without a lawyer. Due diligence, which is very important. Then get on to some of the important contractual terms like warranties and indemnities, personal guarantees. And then lastly, we'll talk about execution, which is something that is often overlooked and mistakes get made. So the first part is a pre-contractual agreement. It's known by many names like a heads of agreement or a term sheet or a letter of intent or a memorandum of understanding. Generally, when parties enter into these agreements, they intend them to be non-binding. It's just a summary of summary of our discussions, and we're going to get lawyers involved. We're going to sign something else. And parties often prepare these agreements themselves. They don't get lawyers to do them. Problem is that that often what the parties intend is not what the agreement reflects and how it might be construed by a court. So this is the only case I'm going to discuss here today. I know you don't want to listen to boring case law, but there was an important case called Masters and Cameron, which looked at these sort of heads of agreement and said that the important thing is the intention of the party. So there are 3 possibilities. You might enter a heads of agreement and intend it not to be binding. It only takes effect when you enter a subsequent agreement. Then there's another type where you enter into a heads of agreement and it's binding, but it's conditional on you entering into a second agreement. And the third possibility is you intend the heads of agreement to be binding, notwithstanding you enter into a formal agreement. And I think the parties often don't understand that. They think, well, this is just a heads of agreement. We're not lawyers. We just put it together. We'll get someone else in. But issues can arise if negotiations break down, you don't get a lawyer, something goes wrong, a party can rely on that. And I've seen clients put together heads of agreement that read to me like they're proper contracts. So what I'd always say to people is make it very clear in your heads of agreement what terms are binding and what terms are not binding. So for example, you'd want a confidentiality clause saying any information I give to you is confidential. It's strictly confidential. You can't disclose it to third parties. You'd want an exclusivity clause saying, a buyer, I should say, would probably want an exclusivity clause, probably not a seller saying, we're having discussions, we're spending money, you can't be talking to someone else, entering into another deal during a certain period of time. Non-solicitation clause, like you can't solicit our clients or our employees, because really it's about sharing information before you enter into a transaction. Non-binding terms would be things like price and other conditions. I often say, keep it simple, stupid. I once had a client who put together a 12-page heads of agreement, and he wanted me to look at it. And I said, look, it reads to me like it's a contract. It's too complicated. I would say to parties, just have a very simple term sheet summarizing it, saying this is not binding, this is non-binding. We'll enter in another agreement. Don't make it too complicated. And I also say, get a lawyer to look at these things because, it might cost you a few $1,000s perhaps, but it's money well spent because even at the preliminary stage of a contract, things can go wrong. And I also want to talk about misrepresentation. So a lot of people think, well, if I have a written contract, well, that's it. All the terms are in there. But actually, you can make oral misrepresentations. You can have oral terms of an agreement. Usually, there's a rule called the parole evidence rule, which is up there, which is a presumption that a written agreement contains everything. And you also have other clauses called entire agreement clauses. But actually, a pre-contractual oral misrepresentation, you can still be liable for that. So I would always say to people, train your sales staff. Be careful about what you say, even in negotiations, even before you're at a meeting, you're about to sign something. If you make a statement or a representation, for example, if I'm selling you a car and I say, oh, it's got 50,000 kilometers on the clock, but the contract says nothing about it, and then you get the car and you find out it's 100,000 kilometers on the clock. That can be a misrepresentation. You can still be liable for that. So people need to be careful about what they say, even before they enter into a contract. And misleading, deceptive conduct, that's also something in the Australian consumer law that is outside of contract. So misleading, deceptive behaviour can arise in many cases. So it doesn't really, it's important what's in the written contract, but there are other oral representations that you can be liable for. So moving to the next stage is due diligence. So before you enter into a contract, you want to make sure who you're dealing with, who are this person. So whenever I get a new client and they say, I'm dealing with this company, I'll say, great. I'd do an ASIC search. I'd want to find out who the directors are, who the shareholders are, who the parent companies are. If they're dealing with land, I want to do a title search, make sure they own the property. I'd want to do an ABN search. An ABN search is free. Someone gives you an ABN, you can search it. Who is it? Is it a trust? Who are they? Are they registered for GST? If you're dealing with a trust or a partnership, I'd want to see a copy of the deed. And if you're an individual saying, I represent someone else or I represent some company, you'd want a power of attorney agency agreement. So you just want to make sure who you're dealing with is the right person. There's no fraud or anything like that. So I do a lot of sale of business transactions. So some of this might not be applicable for other transactions, but the whole point of due diligence is verifying who you're dealing with. Do they own the assets? If they say they own intellectual property, do they have a license agreement? Do they have a registered trademark? Do they, if they own property, do they own the property? Have you done a title search? Have you seen their employment agreements? If you're in a business where you need a license or approval, have they got that? And with accounting, financial information, you employ accountants and you check this. So the whole point of due diligence is verifying, they are who they say they are. They own the business, or they own the right to conduct the business, and checking that stuff out. With confidentiality agreements, if you're doing due diligence, and before you've got to the stage of we're entering into a contract, you're exchanging sensitive information. And this is another thing where a lot of clients end up doing their own confidentiality agreement or non-disclosure agreement. Again, it's always important, I think, to get a lawyer. A lawyer might charge you a few $100s just to look at it, but that's very important because this kind of information, if it gets out there, can do a lot of damage. I had a client recently who was thinking about having a merger with a competitor, and was very concerned about giving pricing information and the prices he bought stuff for and sold stuff for. So maybe you redact that information. Maybe you have an agreement that once we sign an agreement, maybe later on I'll release this information, then we can bargain about price. But as long as you're bound at that stage, so it's very important to think an NDA is a piece of paper, and you can go to court to sue and fight over it, but it's always important to keep that information. Once the genie's out of the bottle, it can be hard to put back in. The third topic I want to talk about is warranties and indemnities. These are probably, and together with personal guarantees, these are probably the most important contractual terms you want to look at. And sometimes, I talk to clients about warranties and they think, like at Harvey Norman, I bought a fridge, I got a 12-month warranty. Is that the same thing? It's not really. A warranty, the legal definition of warranties is a promise about a state of affairs. Like, for example, the equipment is working, we're not in breach of contracts, we don't have any disputes, we're not insolvent, we're complying with law. And these warranties are always important anytime you want to do a deal with someone, it's a supply of goods or buying a business or anything. You're entering into the contract on the basis of promises about certain things. If you breach a warranty, you're liable for damages. If you're given a personal guarantee, you could be personally liable. And some warranties are so important, they could actually be conditions of a contract that, if I'm selling you property, but I don't actually own the property, that's so fundamental, the whole contract could come to an end. So warranties are very important. I spoke before about you can have oral and written agreements, oral and written warranties. So it's not only what's in the written contract, there could be oral statements, even things by emails. A contract could be evidenced by email. So you need to be important. Need to be careful what you put in an email, what you say to people. And there are express and implied warranties. So an express warranty would be what's written in the contract. And you tie that in with due diligence. You own the goods, you can sell the goods, you have title to the goods, you haven't broken the law, stuff like that. So tie it up with what you've done in due diligence before you got there. Things like I can enter into the contract, not insolvent, stuff like that. Implied warranties is also something that people need to be aware of, because again, what's written in the contract is not always everything. You can have contracts, you can have warranties implied by law that according to legislation, you can't contract out of them. They just apply to everything. You can also have implied warranties that, depending on the particular industry you're in, those kind of terms apply to every dealing. And also a history of trading with someone. You know, you might have dealt with someone for years, you might not have a written contract, but you've always done things a certain way. So those can be implied terms and warranties too. I also want to talk about the Australian consumer law, because there are terms of the Australian consumer law called consumer guarantees, and they apply to transactions where it's for personal, domestic, or household use, or a commercial transaction that's less than $100,000. So, for example, if you buy a boat for $200,000 to take your family out on the weekend, that would be a consumer transaction. If you're buying a boat to ferry people and for commercial reasons for $200,000, that wouldn't be a consumer transaction. But what the consumer guarantees do, they reflect a lot of implied terms. So things like, you know, if you're selling goods, you have title to them. They're of merchantable quality or acceptable quality. They're fit for the purpose. If you're providing services, you have due care and skill and diligence. You will provide services in a reasonable time. So even if the contract says nothing about these things, if it's a consumer transaction or a commercial transaction for less than $100,000, these terms apply. And they cannot be excluded, restricted, or modified by contract. Indemnities is another thing. So usually in concert with warranties, you have indemnities saying we indemnify you against any breach of a term or a warranty. This is something that parties often fight over a lot. And you don't really need an indemnity clause because you can rely on common law contractual damages, but an indemnity can extend to legal costs, and you can recover, you can be made whole, you can recover anything. So warranties and indemnities, I think, are two of the really important things that you need to look at anytime you have a contract. And if you're a party that's giving a warranty or giving indemnity, and sometimes it's both parties, you need to think about how to limit your liability. So these will be things like a cap on damages. You know, often a contract will say, you know, if we're paying you $1 million for the goods, well, our maximum liability is $1 million. We're not going to pay you more than that. If we're selling $1 million of goods, we're not liable for $2 million of damages. You might also want a claim period, because if you breach a contract, you have a period of 6 years to bring a claim. If you breach a deed, you have a period of 12 years to bring a claim. So parties often want to reduce that, maybe 12 months, maybe 24 months. Maybe if you paid a deposit or there was deferred consideration, maybe you want a period where tie that in. So if there's a warranty claim within 12 months, that money is released to you. Otherwise, we walk away. Another thing we often get asked about is consequential loss, which is difficult to define. That's flow-on losses. So you might have a direct loss, which is something, you know, I damage your property, the direct cost will be repairing it. Consequential loss might be I damage your property, you can't use it for a commercial venture for 3 months. You lost revenue because of that. So now it's 3 months of damages in addition to repair. So often parties will want to say, I don't want to be liable for consequential loss. It's too much exposure. And the fourth thing that I often see with limitation of liability clauses is exclusion of implied terms, like we said before. There might be terms implied by custom or trade usage, about a certain time I'll supply goods. There are certain, like the Australian consumer law terms can't be excluded, and some legislation can't be excluded. But there's also some implied terms you can exclude. So you're, as much as possible, you want to say the written contract is everything. Fourth topic I'm getting on to, personal guarantees, is another thing I always tell people to watch out for if you're signing a contract. And it can be a bit hidden sometimes. You can sign up to terms and conditions, and when you sign it, it might just appear you're signing for the company, but there might be a clause saying any director who signs this is giving a personal guarantee. The reason parties ask for personal guarantees is basically that a limited liability company, it's a shareholder's liability in a company is limited to what they've contributed to the share capital. It's usually a nominal amount. The shareholders usually aren't liable for the debts of the company. The directors usually won't be liable unless they've done something wrong, like insolvent trading. So if I was dealing with a company that only had $1 of share capital, I want to be protected. I want to make sure a person is guaranteeing it so I can go after their assets. if you're asked to give a personal guarantee, it's obviously dangerous because your personal assets, like a family home, could be at risk if you default. So you obviously, first instance, you'd probably push back and say, I don't want a personal guarantee. If you have to give a personal guarantee, what do you do then? I get asked by clients here, what can I do? How can I protect my assets if I'm a director? I have to give a personal guarantee. The easiest way is to not have any assets in your name. But if you do have any assets in the name, and you always have to get specific advice to your circumstances. So we're not giving legal advice here, but one thing you think about is discretionary trust, having assets in discretionary trust that aren't fixed assets. So creditors might not be able to get to that. And you also need to think about things like voidable transactions. So often a director might be liable for something and they'll transfer their share of their house to their wife for $1. Those kind of transactions can be clawed back. They can be, a trustee can bankruptcy can, claw back those transactions. So it's very important at the outset, if you're a director of a company and you're giving personal guarantees, talk to your accountants, talk to your lawyers. What's the best structure in which to own my assets and to protect my assets in the case of something going wrong with the business, and always get specific advice. And the last topic I want to talk about is execution of contracts. Because I see problems happen here all the time where parties will be negotiating for months. They get to the end of the deal and they, uncork the champagne. Oh, it's all done. But they don't properly sign it. I've seen contracts where, the parties aren't properly described. So someone will describe it by the trading name rather than company name. And that could be an invalid contract because only a company can enter into a contract, not a business name. So you need to make sure there's always the entity you're contracting with. If they're a company, they're described as so-and-so limited or so-and-so proprietary limited. And again, back to what we discussed before about due diligence, do an ABN search, do an ACN search. Who are the parties you're dealing with? Who are the directors? That's important at the outset if you're going to do a deal. Also, always include the ACN or the ABN because a company name can change. You can change the name of your company tomorrow and then there might be a dispute. Who was the company you entered into a contract with? So every company is described by an ACN and that can't change even if the name changes. So I'd always have a proper description, LTD or PTL LTD, an ACN. If it's a trustee of a trust, and you can always check this on ABN Lookup, a free government website. If the ABN and the ACN match up, except for a couple of numbers that start, then the company's acting on its own. If they're different, the company's acting as trustee, and that raises issues. You want them as trustee of a trust so you can get at the trust assets. And again, I have clients who often come to me, they might handle their own transaction, do their own contracts, and a dispute arises. And I'll say, send me the contract. They'll send me a contract, only one party signed it. That's the record they have. Or maybe no party signed. Maybe they have a contract that looks like it's still a draft contract. I don't know if this was the final version or not. Or it's undated, and they'll say, I have, this guy was supposed to pay me 12 months after signing. I'll say, great. Well, when was the contract signed? Oh, I don't know. So you always need to make sure you keep proper records. When a contract's signed, make sure both parties have signed it. It's dated. Don't forget about that because years later, you might not have the records. You might not have the emails. It might be lost. Always keep a contract signed by every party and dated. And nowadays, since COVID has hit, electronic exchange is okay. So before you had to give originals, and it's still a good idea to get originals, but now you can have a scanned signed copy and exchange by emails. And I think that's the best way because you have a record of when it was sent and what was sent. It's better than a fax, for example. And another thing, you don't always have to sign contracts. An unsigned contract can be binding, but there's a presumption that anyone who signs a contract is bound by it. So things like terms and conditions, if I give you my terms and conditions and say, this is what I'm trading on, if you don't sign it, as long as I've given you notice of it, you can still be bound by it. So the classic example in law school is if I go and park my car in a parking lot, there's a sign up saying, if your car gets broken into, we're not liable. You're bound by that because you had notice of it, even if you never signed anything. The last point I want to make before I hold on to Gigi is make sure the contract was properly signed. Again, something that's often overlooked. If it's a company, and there's only one director, only that director needs to sign. If the company has two or more directors, two of them need to sign. Going back to what we said before, do due diligence. Who are the parties? Who are the directors? Have I got signatures from both of them? Under the Corporations Act, you can assume that if the ASIC register says these two people are the directors and they've signed it, you can assume that the party's bound by it. I often see contracts where someone's described as a manager or a finance manager and they've signed the contract. That's not always binding. It can be if that party had authority. If they say I have authority, well, I'd say show me a board minute or show me some evidence that you have authority to bind the company. But on its own, a manager or a finance manager doesn't have authority. Always get directors to sign on behalf of companies. For an individual, you could have someone acting on their behalf. They could be a power of attorney, in which case, show me the power of attorney document. If you're dealing with land, the power of attorney has to be registered. And again, agency, someone might act on behalf of someone. Show me a copy of the agency agreement. So trying to tie it all back in and make, for it all to make sense, due diligence, execution, the right people signing, the right terms, personal warranties, indemnities, personal guarantees, it's all connected. It all goes together. Just before I head off to Gigi, we're not giving legal advice, as I said. This is just general information, but particularly things about structuring your assets, get legal advice specific to your circumstances. And in any part of this transaction, I think always get a lawyer. Now, time to hand off to Gigi.
Thank you, Doug. Good morning, everyone. Now we come to the second half of the webinar, 3 steps to take if something goes wrong. When you enter into a commercial arrangement with another party, things may not always go as expected. There may be a delay in the work or the payment, or the work may not be of expected quality, just to name a few. There could be many steps that you can take when something goes wrong. But I have picked 3 steps that from experience, I think will be useful to consider when a dispute arises. Step 1, try to resolve the matter between yourselves. Step 2, consider alternative dispute resolution. Step 3, taking the matter to court. I will explain each of these steps and point out some of the things that you should consider, and we'll take any questions at the end. Now go to our 3 steps. Step 1. Sometimes disputes can be resolved by simply talking things out. If both parties have the intention of preserving the relationship, an open discussion about how to move the matter forward can benefit both parties and allow you to continue a professional relationship. Before you approach the other party, you should understand your contract. Consider the cost involved, talk to a lawyer, consider writing a letter of demand, and always be prepared to negotiate. Understand the terms of your contract. In most situations, you would have a written formal agreement. In situations where a formal agreement is not prepared, you may refer to emails and other communications between yourselves, which may constitute an agreement and may provide some insights into the terms that the parties have committed to. Review the contract with the dispute in mind. For example, if you are not happy with the services provided by the contractor, review the wording of the contract that sets out the contractor's obligations in providing those services and see if they have breached those terms. This step is crucial in understanding your contractual rights. Check to see if your contract contains a dispute resolution clause. This clause usually sets out the steps that the parties must follow when a dispute arises. For example, a party may need to give a notice of dispute to the other party. It may set out a time frame for the other party to respond, perhaps another time frame for when the parties are to meet and discuss. If your contract has been affected by the COVID-19 pandemic, check to see if your contract also contains a force majeure clause. A force majeure clause is a clause which relieves a party from performing its contractual obligations when an unforeseeable event beyond any party's control has occurred. We recommend that you check whether the COVID-19 pandemic falls within the definition of a force majeure event in the contract. Frustration of a contract means that the contract has become impossible to perform due to a significant change of external circumstances through no fault of the parties, for example, COVID. Frustration brings a contract to an end automatically without any act of the parties. And I strongly recommend you seek legal advice if you think this may apply to your circumstances. Next, we consider the different costs involved. The purpose of assessing the disputed amount is really to determine whether litigation is actually worthwhile. The total amount you claim may include outstanding payments, loss of revenue, expenses from additional costs incurred, and so on. If the damages suffered are inconsequential, then litigation may not be the best option. Because at the end of the day, although you may be able to recover some legal costs, you may still be out of pocket after paying other legal fees. Consider how much you are willing to pay in legal fees. Sometimes it may be cheaper for you to resolve the matter privately or through alternative dispute resolution, which I'll explain later. I have had matters where the disputed amount is just over $5,000. And as a matter of principle, everyone will want to try and recover that. What happens is $5,000, this falls within the small claims division of a local court, where legal fees are scaled and capped. What that means is that you will only be awarded a fixed amount of legal fees, no matter how much you've spent, which is determined on a scale depending on the amount of the claim, even if you're successful. But you can imagine the amount of work involved in a litigation is still the same. For example, drafting, initiating documents, usually in the form of a statement of claim, dealing with the defenses, preparing evidence, and preparing for the hearing. The legal costs in running a hearing will easily outweigh the claim. That, in my view, is not a desirable outcome. Thirdly, consider the other party's ability to meet the claim. That is, if they have enough assets to cover any court judgment. This point is often overlooked, but very, very important. I recommend you do relevant searches on the other party's financial circumstances. For example, property searches or bankruptcy search. If the other party does not have ability to pay, it will be very difficult to enforce a judgment. A judgment that cannot be enforced is a hollow judgment. Talk to your lawyer. Client often asks the question, when should I get a lawyer involved? My answer would be, as soon as practicable, and definitely not when you have decided to take the matter to court. Talking to a lawyer early will assist you in understanding your contract and your legal rights and positions. I find that clients usually get a better outcome if they seek legal advice early. This minimizes the risk of making any mistakes that may affect your bargaining power down the track, which could lead to a more compromised outcome. When you meet with your lawyer, bring all relevant documentation, including your contract and all relevant correspondences you have with the other party. You may ask questions that will help you decide what to do. Questions like, do I have a claim? What are my prospects of success if the matter goes to court? How long will the matter take from start to finish with a court determination? How much is it likely to cost? What legal remedies do I have? What options do I have in resolving the matter? When you have done all that, consider writing a letter of demand. Sending a letter of demand to the other party may help formalize your position regarding the debt owed, allow the other party an opportunity to respond, encourage the other party to enter settlement negotiations. A letter of demand should clearly state the matter in dispute, your position, and what you are demanding the other party to do. Set a time frame for the other party to meet the demand and what steps you would take if the other party fails to meet the demand. If the other party responds to the letter of demand before you start negotiating, I suggest you do this. List out what you want to achieve from the negotiation. Consider what concessions you are willing to make and your bottom line position. Consider how you want to conduct a negotiation. Do you want to write to each other, meeting face-to-face, video conference, or over the phone? And also consider who you want to bring with you if the parties have decided to meet. Generally, negotiations like that are conducted on a without prejudice basis. What that means is that the content of the negotiation, including any concessions made, any offers exchanged, cannot be used in court proceedings without the parties' consent. If you happen to reach settlement, it is important to make any agreement in writing. If settlement agreement is usually in the form of a deed of settlement and release, setting out the terms of the contract, setting out the terms of the settlement, for example, payment terms, how much is paying or when to pay, and that the parties will release each other from all future claims arising from the same subject matter of the dispute. It is very important to seek legal advice before entering into any deed of settlement and release to ensure that the deed covers all bases and that you are not releasing the other party more than what you should. And ideally, this kind of deed should be drafted and reviewed by lawyers. Step 2. If resolving the dispute between the parties is not successful, you may consider dispute resolution. Alternative dispute resolution, often called ADR. ADR is when an independent third party comes in to assist the parties in resolving the dispute. It is an alternative to going to court. The most common types of ADRs are mediation and arbitration. Some contracts may have a clause, usually as part of the dispute resolution clause, that requires the party to go through maybe an ADR process before the party can actually take the matter to court. Why do people choose ADRs? Well, some people choose ADR because they find it a little bit more flexible and less formal than going to court. ADR may also offer a different or wider range of solutions than what a court can order. ADR can also be cooperative. The parties have the option to work together with a mediator or arbitrator to resolve the dispute and come to a settlement, rather than working against each other. This can help preserve commercial relationships. Unlike the court system, when everything is on a public record, the whole ADR process can remain confidential. This can be particularly useful to protect confidential information and maybe trade secrets. However, ADR may not be suitable for every dispute. Depending on the type of ADR, it may or may not be cheaper to run or quicker than going to court. The timing also depends on the attitude of the parties and how they conduct those matters. Procedural rules that govern the conduct of court proceedings may not apply to ADR. For example, there are very strict rules of evidence that applies in the court hearings, where certain evidence like hearsay evidence may not be admissible in court. However, the rules of evidence may not apply in ADR. This may actually work in your favor or perhaps against you. Effective ADR requires that the parties have the capacity to bargain effectively. In situations where there are unbalanced power between the parties, particularly when one party is not legally represented, this may hinder settlement. There may be difficulty in enforcing ADR agreements when a party does not follow through or comply with a settlement agreement. That means you will have more work to do before you get an outcome. Let's have a look at the two most common types of ADR: mediation and arbitration. First, mediation. Mediation is when an impartial third party comes in and guides the parties through a structured process to assist in the resolution of the dispute. The mediator will not make the decision for the parties, but can assist in identifying and narrowing down the issues in dispute, as well as assisting the party in reaching settlement and formulating settlement terms. Agreement reached in mediation may not be usually binding unless the agreement is put in writing. That is why it is important for the agreement to include all the operative terms of the settlement and have the agreement signed and kept by both parties as records. Arbitration. When compared to mediation, arbitration is a more formal process and more akin to court proceedings. The parties may also choose the arbitrator, and the arbitrator can be conducted confidentially. In arbitration, the parties present their respective arguments and evidence to the arbitrator, who ultimately creates a binding determination, which is called an award. Unlike court proceedings, where it is case managed by the court to make sure things move along and progress efficiently, by making orders which requires the parties to comply along the way, arbitrations can take a very long time to finish. I've seen arbitrations that run for 10 years. As I said earlier, the effectiveness and efficiency of ADR depends on the attitude and the conduct of the parties. And also, unlike court proceedings, where they are conducted in the court buildings where the parties just turn up at the allocated times, arbitrations parties are responsible for the hiring of the venue, setting up sound and recording system, paying the arbitrator's costs, etc. Such setup costs are usually shared between the parties, and the arbitrator will determine the proportion in which they are shared when he makes a final decision. The choice between mediation and arbitration largely dependent on the individual circumstances and disputes. It is recommended that you obtain legal advice to help you determine which option is best for you. Step 3, going to court. If negotiation fails and the negotiations are taking too long, or you feel that you're getting nowhere, or you have gone through ADRs, or you have simply decided not to, the next step to consider is taking the matter to court. A court decision is binding and enforceable and will provide you with a more definitive outcome. However, going to court can be costly, stressful, and takes a significant amount of time from start to finish. If you also do not have much control of the outcome. The decision is made by a judge. Therefore, there is a certain level of uncertainty. You run the risk that the final judgment could be worse than what you initially are prepared to settle. The costs in proceedings are usually costs following the event. What that means is that the losing party is often ordered to pay the legal costs of the winning party. That being said, the legal costs of the winning party are not usually fully covered. In usual circumstances, approximately 60% to 70% of the costs are covered. And in some circumstances, the winning party may get a little bit more than the 60, 70%. For example, when an offer of compromise or a Calder Bank offer is made. What that means is that the winning party has previously made an offer to the losing party and was able to achieve a better outcome in the hearing than what was offered. Then the winning party may be able to claim costs on an indemnity basis, which is a slightly higher percentage than the 60 to 70%. Therefore, before commencing proceedings, you should consider the risk of paying the other party's costs in the event that you're not successful. Once a matter is in the court, it will follow its path until final judgment or when the proceedings are discontinued. A discontinuing party may also be ordered to pay the party's costs. So you need to be aware that once a matter is in court, it's in until it's finished. Court proceedings also remain on the public record. The public will be able to access the final judgment made on your case. Next, I will discuss 4 things that you should be aware before taking the matter to court, something for you to consider. 1, which court should I file the claim in? The appropriate jurisdiction will depend on the subject matter and the amount of the claim. For contractual dispute, you may consider going to the local court, the district court, or the Supreme Court, depending on the amount claimed. The local court has 2 divisions. Small claims division deals with claims up to $10,000. General division deals with claims up to $100,000. The district court deals with claims up to $750,000, and the Supreme Court deals with claims above $750,000. 2. What is the limitation period that applies to my case? The limitation period is a time limit within which to bring a claim. After the expiration of the limitation period, it will be very difficult for you to make a claim. That is why it is important to determine what limitation period applies to your matter. How long can I leave the matter or continue to negotiate before it is too late to issue court proceedings? Limitation periods vary between different types of actions. For contractual claims, the limitation period is usually 6 years from the date of the alleged breach of the terms of the contract. The date from when you start counting the 6 years could be the delay when you realize that there is a breach, or the day when the breach is actually committed. For example, defective work could constitute a breach of the contract. However, if the defective work is not discovered until a later date, that later date can then be the start date from when you start counting the 6 years. That is why it is important that you talk to your lawyer early to find out what limitation period applies, when it expires, or in circumstances when the limitation period has expired, whether an extension may be sought. 3. Urgent court applications. As I said earlier, court proceedings takes time. There may be circumstances where urgent court applications are required. For example, you may require an application to request for an extension of time, pre-litigation discovery to request the other parties to produce documents, or an application to seek an order to preserve rights or property before court proceedings are actually commenced. Some urgent applications are injunction, that is to stop someone from doing something. For example, if you need to stop someone from launching a product, or you need to stop someone from broadcasting something which will lead to copyright infringement from which you would suffer a loss, you may apply for an urgent injunction to stop that person from doing just that. The onus is on the applicant of the injunction to satisfy the court with evidence as to why an injunction should be granted. Freezing orders. They also call Mariva injunctions. It is a type of injunction that prevents a person or an entity from disposing of its assets. For example, if you think the other party is likely to dispose of its assets to defeat any judgment made against it, you may seek a freezing order at the commencement or during the course of the proceedings. Again, the onus is on the applicant of the freezing order. These sort of orders can also be granted against a third party. Search orders, also known as Anton Piller's orders. This order authorizes the seizure of documents and other evidence from another party's premises. The purpose of such an order is to preserve evidence that may be required to prove your claim and that you have reasons to believe that it is in danger of being destroyed. 4. What are the possible remedies that can be obtained through the court? When the court makes a final decision, the court may make a number of possible remedies. The most common type of remedies is usually in the form of payment of money. Different types of damages include compensatory damages. This is awarded to compensate you for the losses you have suffered. This may include loss of profits, loss of income, loss of opportunity, etc. Liquidated damages. Liquidated damages are those damages that can be quantified. For example, unpaid rent, unpaid loan repayment, unpaid invoices for services or products. Other than monetary damages, the court may also make orders for specific performance. As the name suggests, it is an order that requires a party to specifically perform and fulfill its obligation under the contract. This is a specialized remedy when no other remedy, such as the payment of money, will adequately compensate the injured party who has suffered loss due to non-performance of the contract. This order aims to put the injured party in a position he or she would have enjoyed have the contract been fully performed. Injunction. As I mentioned earlier, an injunction may be ordered to restrain a person or an entity from doing a wrongful act. Rescission. Rescission allows a non-bridging party to cancel the contract. This puts the parties back in the position they would have had if they had never entered into the contract. In closing, let me summarize. Whilst we would try to make things right when entering into a contract, there could always be circumstances outside your control that something goes wrong. When that happens, it is recommended that you first try to resolve the matter between yourselves by talking to each other. But if that fails, you may consider getting a mediator or an arbitrator involved, or you may ultimately decide to bring the matter to court. We recommend that you talk to your lawyer as soon as practicable when a dispute arises. Your lawyer will be able to help you understand your legal rights and position under the contract and also the relevant law, guide you through any negotiation process, help you manage your expectations, develop a strategy, as well as to explore the different options available to you and advise you what is best for you. I hope you have enjoyed this webinar and find it useful. We may have time for questions, but if you wish to ask any questions after the presentation, contact me via the contact details that is on the screen now. Doug and I have also prepared a checklist on some of the topics that we have talked about, which you may find helpful and handy in the future. If you are interested to receive a copy, please feel free to email us. Thank you for joining.